Welcome to the monthly Truck Stop webinar provided by the Motor Carriers Insurance Education Foundation as a part of the Transportation Risk Specialist program. The Truck Stops are presented the second Thursday of each month at 2 p.m. Eastern Time. These webinars are presented as industry update and for information purposes only and do not qualify for state CE credit. If you're seeking state CE credit, please notify our office at trs@ibci.net and we'll send you the information on the CE opportunities. If you have questions, please type them in the chat window. They will be answered as time allows or responded to after the webinar via email. And if they are pertinent, we'll share them with everybody who attended. If you have experienced any audio problems, please contact us also in the note by typing the note in the chat window or call our number at 800-741-4084. We will attempt to correct the problem as soon as possible. Now let's get to the webinar. Protecting your livelihood, unauthorized passengers. We in the insurance industry deal all the time with other than employees in our vehicles. Our insurers say we want more, we want a ride along, we want these situations, and it comes up. We in the insurance industry obviously do not like anybody in there. So Bridgette Blitch, Bridgette, I'm sorry, Taylor Associates in Winter Haven, Florida, has put a program together that will lead us through this complicated situation that comes up often in our industry. Welcome, Bridgette.
Thank you, Tommy. Always a pleasure to be here.
Let's start with it. Let's tell us the scenario you got set up for us. Walk through this with you.
Yeah, so I want to set the stage for some of the issues that we're going to discuss in this webinar today. And I think the best way to do that is to set it up with a fact pattern. And this is going to be, I think, common for a lot of our audience, the scenario. So this is based on an actual case. So here's the situation. Last year, while en route for Hopeful Transport, Harold Donner, who's a driver, met the plaintiff at a truck stop in Houston, Texas. The plaintiff asked him for a ride, and Harold consented, notwithstanding the fact that HTI, we'll call Hopeful Transport HTI, had a written policy prohibiting drivers from carrying passengers. The plaintiff did not have a particular destination in mind and decided to ride with Harold for several weeks. On, in this case, November 22nd, 2016, Harold was driving the truck on a mountain highway near Elkins, West Virginia, when he lost control of the truck and went down the side of the mountain. Both Harold and the plaintiff were injured. The plaintiff, who was 24 years old at the time, was rendered a quadriplegic, although she has since regained some of the use of her arms. So I bring that situation up because it's going to guide us through some of the issues that we're going to discuss today, which is, what is the law? What does the law say to drivers, to motor carriers who want to bring passengers in their commercial motor vehicles? What is the best practice that motor carriers and drivers should employ when they decide to bring on a passenger? So what qualifications do we want to look for in our drivers? And also, what do we want to look for before we authorize a passenger? And then Tommy will help us in guiding through the insurance issues as to what happens if there is an accident. What insurance is available to cover drivers and passengers? And then also what other policies may be implicated by the fact that you have a passenger in the vehicle, which then will lead us also to the discussion of what is the liability exposure when a commercial motor vehicle accident happens. And recall, just because you have insurance does not mean that that passenger is not going to file suit against the motor carrier. And then what can we do to prevent or protect or mitigate our damages, that is the damages of the insured motor carrier, if they do decide to take on a passenger, and we'll look at forms of releases of liability.
Bridgette, the concern that we have in the insurance industry, as I expressed in opening, is we don't like any passenger in there. So I guess we've got a couple situations. This was an inadvertently. This was where the driver went beyond his authorized duty. Before we get through, I want to talk about how that would be different if they are a true employee versus an owner-operator, but we'll talk about that somewhere down the line. Second part of it is there is a pressure, and what we hear from a lot of our insureds is, look, we want to keep our drivers happy. They're away from home for weeks at a time, and so we want to allow them to operate or to bring their family members or their significant others. Typically would never want to look at a child, but a typically other to come in the vehicle with us to make them happy, to keep them there. And so I guess we have those situations where you have someone here who's inadvertently picked up beyond authorization there. Second is, can they do it or not, and how they do it legally is what you're going to talk about if they come to us. And this becomes an insurance concern as we have. So let's walk through this here. I got this next slide up where you wrote up the overview, Bridgette. Let's talk about it from here.
Okay. All right. So if you want to switch to the next slide, we're gonna move on to what is the law, right? Okay. So we have the operational considerations. One is, as a matter of policy, do we want to prohibit passengers altogether versus what the law provides? So the law states that unless specifically authorized in writing to do so by the motor carrier under whose authority the commercial motor vehicle is being operated, no driver shall transport any person or permit any person to be transported on any commercial motor vehicle other than a bus. All right, so we can have a passenger, but we're going to have to follow the steps and the requirements under the statute before that passenger is authorized. And we're going to talk, like you mentioned, Tommy, about whether or not companies make the operational consideration to accommodate their drivers, whether they want to allow passengers or not.
Love it. So, can we stop here for a minute? In the either owner operator agreements and or the handbook for the drivers, so you think most of those should always address it one way or the other, either no passengers at all, or if you want a passenger, here's a step to apply to us for us to allow to do it. That would be the first question. Second question is, and I've had this discussed before, and I think I heard that the authorization does not have to be in the vehicle. It just has to be back at the motor carrier's location. But is that correct or not?
It's correct.
Okay.
So, yes, and that is an excellent point. So if the decision is made to allow passengers, if it's, for example, in an independent contractor agreement, you would have in your independent contractor agreement the recital that says passengers are permitted upon authorization, and you would have an addendum or a form that meets the requirements of the statute to allow passengers, or you would say passengers are not permitted. If it's same is true if it's an employee driver, right? You would have then your policy, your company policy that says drivers are not permitted, or excuse me, passengers are not permitted on the commercial motor vehicle. So yes, one way or the other, regardless of whether you have an independent contractor-based model, an employee-based model, or a combination of both, that position of the motor carrier as to whether or not they accept passengers needs to be communicated to the driver. Now,
we're talking about if it's going to happen, here's the law and here's how to do it. Also, and we can walk through this, Bridgette, remind me to also say, if like this gentleman here who picked this person up that fell down, or that went on the side of the mountain in West Virginia, when they violate the rule, what does that lead to? That's a concern too, is it not?
Yeah, so, unfortunately in that case, it led to a lawsuit with the passenger suing the motor carrier and suing the driver for personal injury damages. And it can also lead to DOT violations, and it's going to affect the motor carrier on their CSA scores, right?
Well, which is not quite that's not the major consideration here, but it would be one. Okay, we'll talk more about through that. Let's get through how to do it legally. Okay, so go ahead. I'm sorry.
Oh, no problem. So when the authorization is approved, The motor carrier has a form which shall state the name of the person to be transported, so our passenger, the points where the transportation is to begin and end, and the date upon which the authority expires. So that's right there out of our statute. That's the minimum threshold that we have to have in our written authorization.
Okay.
Now, there are a few exceptions to that, and these are the exceptions. So no written authorization is necessary for the transportation of employees, right? Employees or other persons assigned to a commercial motor vehicle by the motor carrier. So an employee means any individual other than an employer who is employed by an employer and who is in the course of his or her employment directly affects the commercial motor vehicle safety. Right now, Tommy, we're going to get into some questions as to whether or not someone is an employee when they're operating or sitting even as a passenger, or perhaps asleep in the cab when an accident happens.
Right.
So
We'll get to the coverage. We'll talk about that. We'll walk through that there. Right.
Right. The other piece to this, some examples: a driver of a commercial motor vehicle, including an independent contractor while in the course of operating a commercial motor vehicle, a mechanic or a freight handler are going to come under this employee definition.
Okay.
Any person transported when aid is being rendered in case of an accident or other emergency is another exception to the written requirement authorization component of this statute. And an accident means a DOT reportable accident. An occurrence involving a commercial motor vehicle operating on a highway in interstate or intrastate commerce, which can result in a fatality, a bodily injury to a person who, as a result of an injury, Tommy, as you know, immediately receives medical treatment away from the scene of an accident, or any one or more motor vehicles incurring disabling damage as a result of the accident, which require the motor vehicles to be towed away. All right,
and by definition, if it's an emergency, they need medical treatment, and that's why we're transporting it. Then it falls within that definition, or they wouldn't need to be transported for medical treatment. So that would fall. Right.
So you have the accident component, which is a DOT reportable accident, which is the definition I just went through, and then you have an emergency. Now, there's also a statutory basis for what constitutes emergency. So if somebody's out in the middle of the street and there's a tornado coming down the highway and about to sweep them away, you don't need to have an authorized passenger to ride, right? So you can save people from basically what is an imminent harm, and it's hurricanes, tornadoes, storms, winds, tidal waves, earthquakes. I mean, you think of the emergency, which basically says anything that is going to threaten human life or public welfare, right, is an emergency.
Bridgette, if we remember that, and again, we're talking about different types of trucks, but you remember that discussion with Vegas in the shooting a while back. There was someone who got a bunch of people and got in a truck and put them in a truck to move them away. Again, I don't think it was large enough with DOT numbers and stuff, but that would clearly qualify in this situation. So that's one that has been in the headlines just very recently.
Yes. No, it's a very relevant and unfortunate, yes, of course. But I mean, from the statutory perspective, yes, you're within your right to get those people out of harm's way and take them away. So this is not meant to be so rigid as to come within those parameters. So then the last one is an attendant, delegated to care for livestock. So those are the examples where we do not have to have written authorization to transport passengers.
But in this case, do they have to wear boots and a cowboy hat?
Well, you might
to qualify as a attendant of a livestock. That's the Cowboys. Go ahead. I'm sorry.
No worries. All right. So some exceptions. So this section shall not apply, and this is just following along with the statute, to the operation of a commercial motor vehicle controlled and operated by any farmer and used in the transportation of agricultural commodities or products from a farm, or in the transportation of supplies to this individual's farm. And here we have the definition of a farmer. Any person who operates a farm or is directly involved in the cultivation of land, crops, or livestock, which are owned by that person or under that person's the direct control of that person. So we have a lot of insureds, a lot of clients that are in rural agricultural communities that own farms and trucks, and they're transporting their own products, they're transporting their own supplies, right? And one of the things that comes up occasionally is cargo, right? Right. You can have a shovel mean cargo. So just for purposes of passengers, this is an exception to the passenger to ride statute.
And just a side note, this exception also applies to CDLs. The individual driving this vehicle is not subject to CDLs. I think if they operate within 150 miles of the farm. So that would also apply to the driver themselves being CDL qualified too.
Good note. So, Tommy, you kind of beat me to the punch on your question here. But here's my question is, that's all right. One step ahead of me.
I read through it already, but I didn't. Go ahead.
So this was just to clarify the question that does come up. If Harold was authorized to transport the plaintiff in our case, should you have kept the authorization in the truck? And the question and the answer is, no, it didn't have to be. It needs to be at the carrier's principal place of business, but at the discretion of the motor carrier, a driver can also carry a copy of the authorization. So I've had situations where drivers get pulled over, they don't have the authorization in the truck, and then law enforcement during a roadside inspection calls the trucking company and says, you know, are you aware that there's a passenger in this vehicle, and is this passenger authorized? And if the passenger is not authorized, then I've seen law enforcement issue the citation, or obviously if it is authorized, then they don't necessarily have to face that citation as long as they have proof at their principal place of business of the authority for that passenger to ride the vehicle.
Wouldn't you recommend them having a copy anyway? Because we know the officers get busy looking at a lot of things, and they might not take the time to call, and they might cite it, even though later we could do the data queue and get it down, which is a long process. So wouldn't it be worthwhile, or at least prudent, to maybe have a copy of it with them?
Yeah, as long as there's not any, personal sensitive information of the passenger that's on the form, then yes, the authorization from the safety director, from your trucking company authorizing the passenger does say that does phone call, or the potential data queue challenge, or going before, let's say in Florida, the Commercial Motor Vehicle Review Board.
Right.
All right, so we talked about the law and when a written authorization is required and the exceptions to that. So now let's talk about if the decision is made to permit a passenger on the vehicle, what information should be reviewed. So we want to look at who is the person that we're going to bring on, who is our driver, how experienced is our driver. And then we want to have an application so that we have a form acknowledging the request and the information that we want on that passenger. We also want then that authorization executed by the motor carrier. And we'll talk about the release. While a release of liability is not something that's statutorily required, we do want to have that in place before the passenger gets on the vehicle. Then we also want to have the authorization duration, right? This is right out of the statute, when it begins, month, date, year, and when it ends. And for some of these trips, it may be cyclical, maybe from a terminal to a particular destination and back to the terminal. So for our point of origin and point of destination, it can be to reflect that route over a period of time. And then once the passenger authorization expires, the addendum or renewal, because we don't want that passenger riding in the vehicle once that authorization expires. So what are some examples of what should be considered before passenger is permitted? One example is they must operate a single operation during the passenger's presence on the equipment. They must have been qualified as a driver with a carrier or an affiliated company, let's say for 30 days, and be presently qualified. So qualified means DOT qualified.
Now, Bridgette, we're talking about the driver. We're talking about here, this is a consideration that we have to put in when the driver requests a passenger to ride along with them, right? This is talking about driver qualification.
This is talking about driver qualification. Okay. So we're going to talk about driver qualification. We're going to talk about passenger qualification. Okay. So this is for driver qualification. So do you want it 30 days? Does the insured want it longer than that? What if they pull up their MVR, do we have a reputable driving record to the carrier? And if we look at their annual review of violations, for example, if they've been with us for a year, do they not have any moving violations, or what's the criteria that we're going to allow before this passenger gets on the equipment, because we want to make sure that they have a history of safe driving. Do we want to also show that they've currently and continuously operated with the carrier without a preventable accident, and not, of course, be on any probationary status or less than a satisfactory performance record, right? So this comes into a question of due diligence before we allow our drivers to put someone in their vehicle and operate. We want to make sure that they're not going to be distracted with a passenger in the vehicle, that they've demonstrated correct safety in operating the commercial motor vehicle. So they, it's one thing to have a CDL, but then have to also demonstrate that you can safely operate that vehicle with someone else in the cab with you, so that we don't get into any issues with exposure of putting a passenger in with a driver that's not yet ready to operate a commercial motor vehicle.
And the what we're laying out here is that the rare exceptions, even coming to the insurance companies, when we balance, this is a good driver, we want to keep them, they perform well, and one of the ways to give them an additional benefit is allow them to have a family member riding along with them. And what we're saying here is not be just, it should be done real carefully, is what we're saying here, right, Bridgette, for that being consideration.
Right, because we've got a potential exposure here. We've got, we don't want our driver to get hurt. We don't want the passenger to get hurt. We don't want anybody else to get hurt in the process. And so there's a lot of considerations. There's already a lot going on with just a driver operating a commercial motor vehicle, let alone now adding another person in the vehicle.
And yes, and that other person could be a distraction. I agree with that. Having a couple ex-wives, I know how that could be. Go ahead.
Well, I won't make any comment on this.
Okay.
So some of the contractors' requirements, so talking about here an independent contractor, they have to have a written permission from the owner of the equipment, right? If it's a separate entity or an individual, granting authorization for the passenger on leased equipment, and then must meet all the requirements as outlined by the carrier's driver and the contractor's requirements of the independent contractor agreement. So we want to just, in the independent contractor agreement, if the passenger is going to be permitted, make sure we've just got that authorization in place. Now, keep in mind, we want to be careful. If we're going to allow, we can either say yes or no, we're going to allow a passenger, and you have to comply with statute before we allow the passenger. But if we start controlling the contractor, then we start writing that line of, is this individual an employee? Because now we're controlling their operations. So we stick with the statutory requirements when it comes to contractors and getting authorized passengers. So if it's an operational consideration because of insurance, and therefore we have a business need in order to make a requirement or impose a requirement on a contractor, that's different than controlling them and their operations. The next slide.
All right, yeah.
Now so we talked about the driver requirements or considerations, and also considerations to think of when you have independent contractors that are going to have authorized passengers. Now let's look at the passenger. So obviously we want the passenger to be pre-approved in writing by the carrier. We want proof of identification, that we know the person that is actually in the vehicle is the person that applied for that authorization. If there's any authorized documents, we want to make sure we have those in our records. And the other consideration to this is, what is the condition of our passenger? Do they have any medical conditions that would impair or affect the safety and operation of the commercial motor vehicle? If our passenger has a heart condition, or if our passenger has respiratory issues. So it becomes a situation where it may not be, based on where the driver is located, a safe environment for that passenger, because they may need medical assistance, or they may need to stop in locations where it might not be safe to stop. So we want to make sure that the person that is getting onto the equipment that they've disclosed, or we've been made aware, the insurer has been made aware of who is coming onto our equipment, right? We've talked about also children, right? We want to stay away from children getting onto the commercial motor vehicle for the same reasons, right? We're taking on the potential exposure, even if we have insurance for that passenger. God forbid something happens, that the driver wasn't able to get them to medical assistance soon enough, or put them in a position, in a location where maybe it wasn't the best place to be for that passenger.
So what we're saying, again, being careful with the driver, making sure that you really want to give that to them as a benefit. It's okay to do independent contractors, but that needs to be addressed in the ICA agreement to allow it, and the steps to allow them to request it and then comply with it. And the second or thirdly, we need to make sure the passenger there doesn't create distractions or other problems that would cause the operation of the vehicle to be impaired as they ride down the highway. Very good points, Bridgette. Let's talk about the next one.
At this point, would you rather walk, right?
Right. Yeah. Right.
So. But yeah, I mean, and that's why when you mentioned in the opening that if we can just say no passengers at all, we don't open up this potential liability exposure. Even if you cover all your due diligence, you have the right forms, you have the right insurance, it doesn't mean that, God forbid, an accident happens like it did in the case of Harold, and now you're going to face a lawsuit. Even if, like you said, Harold had an authorized passenger to ride form and our passenger was authorized. So that being said, let's say the decision is made to go ahead and have a passenger, and we want to make sure that we're taking on, as a motor carrier, the insured. We want to do the right thing and make sure that that passenger is covered. So there is a
protect. Not be careful of the word covered, Bridgette. They want to be protected, and they buy their own protection. I'm not sure we can call this coverage, but go ahead. I'm not being semantical, but you know what I'm saying.
Right. So you have a motor carrier that is a participant in an occupational accident policy program, and they have a driver which is considered an insured under the occupational accident program. And there is a provision in the occupational accident policy that talks about if passengers insurance is available in the event a passenger rides on that vehicle. So this is taken from a policy where it says an authorized passenger is traveling with you, an insured person, as defined in the certificate meaning your occupational accident policy, will be covered. A policy provided to authorized passengers traveling with you while you are under dispatch.
So what we're saying is the injuries there, the first claim would be this occupational accident policy for both the driver and the passenger if they have the right wording in the OCAC policy.
Correct. You're going to have to look at what the benefits are under that policy and what the policy states in order to determine whether you're going to have that authorized passenger to ride provision where they are going to, that passenger is going to be covered under the policy. So just taking that language right there. And there's going to be specific information on that policy that's going to tell you what are the type of benefits that are going to be paid out, partial, permanent disability, what are the maximum benefits that are going to be payable out under that policy, the effective date that that policy is going to be in place. This is taken from the policy. Again, the effective date indicated on the passenger authorization form as approved by the participating organization. So that would be the motor carrier. Termination, is the termination of the authorization, what terminates that potential coverage. The restrictions, right? So what if Harold's passenger had operated the commercial motor vehicle? So that could serve to exclude coverage. Or what if instead of an accident, Harold's passenger got injured while unloading cargo? Or what if she had gotten injured and there was a fire at a fueling station, right? She was fueling the vehicle. So those things might serve to limit coverage under that occupational accident policy for benefits that would be payable.
Now,
so
I'm sorry, Bridgette, some programs, this is where we have an occupational policy covering an independent contractor and provisions in that policy that's already covering the independent contractor to extend coverage to the passenger. Now, obviously, there are occupational accident policies out there with the same consideration you have here that you can write individually for that passenger when the driver is an employee covered by work comp. The passenger would not be unless you qualify them as an employee to be covered by comp. And that's a whole different world too that we will discuss. But they could have their own occupational accident policy individually that would have to provide wording in it. And I know some programs that have that. But in either case, what we're saying here is that at least they need to make sure that the passenger has some coverage to take care of their injuries in case they get hurt, so they don't go and try to sue and other things. We're going to talk later. They have the rights to do that, but as long as they're taken care of, typically they don't proceed down that path. Is that what we're saying here?
Yeah, what we're saying is that there are steps that we can take to try to mitigate our potential exposure in the event that Harold's passenger files suit. And like you said, having that policy in place is something that maybe they'll think twice before filing suit, or the policy will be enough to cover the personal injury claims and medical bills that the passenger has to pay as a result of the accident. So by having that coverage, we mitigate our potential liability exposure in the event of an accident.
And speaking of that, the liability exposure.
There you go. So what happens when an accident occurs?
Let's talk about these waivers and all, the release of liability. Talk about how that works and the enforceability and what should be contained in those, Bridgette.
Right. So when an accident happens, of course, there's going to be a lot of different questions about what is available for the passenger. So we talked about insurance, and then if the passenger is going to file suit and become a plaintiff in a personal injury claim, then what damages are they going to try to seek in litigation? And then what defenses does the driver and the motor carrier have in the event that that lawsuit is filed? So one of the questions come up is the question of waivers or releases of liability. Did the insured or the motor carrier have a release of liability in place, in addition to not just the authorization to ride form only grants the authorization for that passenger and meets the federal statutory requirements? It doesn't preclude the passenger from filing suit, and that's why we have the discussion of a liability waiver. So we have
briefly go through the points of viability labor, the 3 or 4 things that should be in place, Bridgette, for a waiver, the wording. Obviously, if they need to contact you, can help them draft it. And I'm sure you drafted some, but what are the 2 or 3 provisions that you need to make sure that's in that waiver?
Right. So this is an issue that's going to be based on state law. There's going to be different requirements under different state law as to whether child waivers are enforceable, right? And also whether waivers of the carrier's own acts of negligence are going to be enforceable, right? So there is, I can't say that I can give you a magic language that is going to apply in all circumstances. The insured is going to have to get qualified counsel in their state where they have their principal place of business, or where they're going to have that waiver be in effect to ensure that that's an enforceable waiver. I can tell you as some general principles, there's often requirements that the language be conspicuous, right? And that it be in bold letters, and that it be clear that the individual is assuming the risk and releases the motor carrier and the driver from all claims, actions, demands, liabilities of any kind arising out of the operation of the commercial motor vehicle, including specifically death and bodily injury, right? So that's some of the, it's not, again, the caveat, you need qualified counsel to ensure such language is enforceable in your jurisdiction. But the take home here is make sure you have that enforceable release of liability in place, such that in the event of this accident, you can bring up that waiver and say, no, the plaintiff assumed the risk, acknowledged, for example, that they were a passenger on the vehicle, and that they were going to release the driver and the motor carrier from any liability in the event of the accident. So they took on that own risk by getting in the vehicle, and therefore their claims for personal injury damages or the estate's claims for wrongful death have been waived, right? And there's a lot of considerations that go into the release. Like, how do you ensure that the release is effective for your estate? If your estate tries to bring a wrongful death claim to get benefits for the heirs of the estate. So those are important discussions to have. And the first question is, do you have a release of liability? Has that release of liability been updated and reviewed with qualified counsel?
And then, is it enforceable, Bridgette? That's the concern. Right.
And so is it enforceable? And that's a matter of state law. Does your state, for example, allow child waivers? Some jurisdictions do not. So and then the question is, do some states allow for the release of the party's own acts of negligence, right? Or what about gross negligence? What if the driver was grossly negligent and had been operating the commercial motor vehicle while under the influence of alcohol or drugs, right? So is that, if you have a release of not only negligence, but gross negligence, right? Is that going to be enforceable? And that kind of...
Go ahead, I'm sorry.
And that goes back to, vetting our drivers, right? If we're going to have these waivers be enforceable. So the take home is to get with your qualified counsel to ensure that release is enforceable in the jurisdiction that you're trying to have that release be executed.
So from here, to this part is the motor carrier has a concern about non-employees being in the vehicles, and they need to upfront discuss that and have a part of either the independent contractor agreement or the owner-operator manual or the condition of employment signed by the driver manual or the conditional employment that says yes or no. If it's yes, they do allow passengers, then there's certain steps they need to have in place. The first one, obviously, is to qualify the driver and do it for a benefit of the motor carrier to keep the driver there, the driver solid. He or she doesn't have any past bad indications that they would lead to a crash and those things. Second, to qualify the passenger because we want them not to be a distraction. We want them to be of sound mind and body so there won't be a problem. And then have that authorization. In the absence of that, they're violating the federal law, but have that authorization there and also try to protect the liability situation by having an occupational accident policy that protects the passenger. And in those cases, Bridgette, as I understand it, even if they sue now and they're collecting an OCAT policy, we get an offset for that from in the suit case because you can't collect twice for the same injuries. So unless it's something bad happens, which usually it would be, then there would be no incentive to sue as long as everything's taken care of. But we all know occupational accident policies have both limits on dollar amounts and times amounts and those kind of things. And then, but we have that in place. And the last thing you have is a waiver that says, I assume the liability. Passenger, you assume the liability. If you get hurt, don't sue us. And then we get worried about enforcing those things. Is that pretty well summarized where we are right now?
Yeah, Tommy, you were listening. I'll give you an A+ on that one.
Okay, but now let's talk about the insurance part of it, okay, Bridgette, and we can go through this here. Here's the problem we have. This is our insurance agreement on all liability policies. It says we will pay for bodily injuries and the insurance legally must pay as damage because of bodily injury, property damage to which the insurance applies. That means it's not excluded, caused by an accident and being a covered auto. So we assume it's a covered auto. We know there's an accident. We know the person here, and the person got involved in it, got hurt. And then if we have work comp in place, then there's no concern here because you have tort immunity in work comp. And Bridgette, I've had some situations where we want a family member. It typically would be a spouse to the driver to keep them happy. I know some situations where the motor carrier qualifies that spouse as a driver and CDL and have them covered by work comp. Or if there's owner operator, have the owner operator have their own work comp policy and cover that passenger in there as a employee of the motor carrier. Have you seen that done, Bridgette, and bring it under work comp so it does not fall back under tort?
Yes, I have seen that. So that work comp is the exclusive remedy.
And if you can, bring it under a comp policy that way. But if it's not comp and they get sued, this is the wording in our policies. Exclusion for employees' identification and liability. We exclude bodily injuries to an employee. And notice that's in quotation marks. And we'll talk more about that definition here in a minute. So the situation there is that if they're an employee, there's no coverage in the policy. If they're an employee, then you should have work comp. If there's no work comp in place, they're still not an employee. I mean, they're still an employee, so the policy doesn't respond. OCAC is not work comp. So even if they're covered by OCAC, they can sue for their injuries. But they would sue not as an employee, but as an independent contractor. And so this is the conflict that we have, is it not, that if they're an employee, meaning on the payroll and raised to the level of employment, then if they sue, then there's no coverage in auto liability policies. Therefore, they got to rely on work comp or their own individual policies, OCAC policies. But that's only employees. If they're independent contractor, or not independent contractor, or not that person that we picked up on that first case, that person they picked up, Bridgette, would not qualify as an employee under any statute I'm aware of. Do you agree with me there, the person who was a quadriplegic?
I agree.
So now they sue, and then they're turned into our auto liability policy. And our liability policy has to respond because they're not a employee. And so, right. And so now you're opening up that liability. And even though you have a waiver, most cases, those waivers can get around often. Is it not true? They don't hold up all the time.
Well, right. That's why I say, do you have one in place, and has it been updated and reviewed by your qualified counsel?
Yeah, and that's you know, that's the concern that we have from a liability standpoint. One of the worst cases I've seen in this was a friend of mine shared this with me, where they had a case where there was the driver and they allowed the wife to drive with them. The driver, the husband, had a accident and killed the wife, and the wife's estate, which is the children of the husband, ended up suing their father for negligence. They killed the mother, and the auto liability policy had to respond. I mean, that is a terrible tort situation, but those things can happen. And you know, and even with in absence of OCAC, I mean, excuse me, absence of work comp, that's how it would go. Correct?
Correct. That you, and even if you had the occupational accident policy in place, I mean, it's not
right. They still can sue.
Right. Lawsuit, but it certainly, you know, can help mitigate the risk that that wife's estate would be suing the husband or the trucking company. Right.
In absence of work comp, I'm sorry, I didn't mean to say absence of work comp, then we're in a tort situation. And so here's the problem. Now, as you know, the definition of employee, as you talked about here, and this is in the federal definition, means any operator of a commercial motor vehicle, including full-time, regular employment in a minute, those kind of things, even independent contractors, and the motor carrier's employer. And so if the vehicles operate with the DOT number on the side and the person's involved in it, then is that person involved in an employee or not? Now, here's the dilemma. The insurance carrier wants that person to be an employee. Why? Because we don't want to pay for their injuries.
Right.
But the motor carrier and or the driver and or the passenger do not want to be an employee because they want somebody to pay for their injuries. And this is the problem here, because the suit's going to be against the motor carrier. And so the insurance company then has to decide how we're going to handle this suit of this passenger. Obviously, they'll bring the waiver in. Obviously, they'll bring all these other kind of things involved in it. But if they're not employed, they still have to address it. So they're going to do everything they can to make them an employee. To make them a non-employee, so the auto liability policy will respond. Where the insurance carrier is going to try to make them an employee so that that policy doesn't respond. Have you seen this conflict?
Absolutely. Right now.
Right now. You got one right. And the landmark case is the Miller versus Northland Insurance Company. This is, I think, a 2013 case, if I'm not mistaken here. And Northland is the liability, and it could be any insurance carrier because this is wording all the policies. And so this is out of the court ruling. And so what the court looked at is the exclusion 4 that we just went through, where the employee no covered for employee. But then they went here and they brought in the motor carrier's enforcement of the state laws do not apply to injuries or death to injury to insurance employees while engaged in the course of their employment. And the employee here go back to the definition we've had. Similar, the federal regulations do not require motor carrier to obtain coverage for injuries to or death to an employee while engaged. Thus, under the policy and the federal law, the key question is whether Mrs. Miller was an employee of the trucking company at time of accident or not. The evidence is undisputed that Mrs. Miller was asleep in the passenger seat at the time of the accident. She and the driver, Wadley, departed from Tennessee with a load to be delivered to 4 stops, the first being in Western New York. Mr. Willis, Waltley, and Miller and Mrs. Miller were sharing the driver responsibility. That's the key part here. They were both sharing the drivers. Mrs. Miller argued that because she was not driving the truck, she was not acting as an employee at the time of accident. In addition, she argued that she was an independent contractor, not an employee, because the problem we have here is she wants tort, and there could be work comp in place, and this case. And then the court said the applicable definition of employee under the federal regulation provides as follows, and that's what I just read. So what this judge did is said the definition of employee in the policy, even though it's in quotation marks as an example, is not a complete definition. So they brought the federal definition into this case and said that she was employee or not. So what? The final line is we must determine whether Mrs. Miller fits this definition, in particular whether even if she were an independent contractor under Tennessee law, she qualifies as an employee here because she was in the course of operating a commercial motor vehicle. So they say even though they found her to be an independent contractor, but also was she still an employee. So based upon this authority and the reasoning of above, whether which they relied, we must conclude that Mrs. Miller was an employee, and therefore there was no coverage in the policy. So the insurance carrier did not have to address the damage to, quote, the co-driver because she was an employee. There's no work comp. Could the motor carrier still be sued, though, Bridgette?
Yeah, the motor carrier can be sued.
And so the judgment of the suits against the motor carrier, and they have absolutely no coverage. And
yeah, this is, you know, a declaratory action as to whether or not the auto liability has an obligation to step up to defend and indemnify. They're insured in this kind of action. So for Northland's part, it's a victory for them because under the employee exclusion, they are able to avoid coverage under that particular policy. But that means that if there's no other policy behind the trucking company in this case, then they are bare, right? And they're left to spend and indemnify on their own dime. Or maybe if the insurance company had been defending them up until this point, now you might have a suit from the insurance company for defense fees.
Well, reservation right under reservation rights, and come back and get that, and that's and there's really no answer to this exposure other than making everybody an employee and covered by comp. I mean, that's the bottom line. But then you do that, then you open up the whole bellywick: are they employees or not? And you got all the federal taxes and stuff involved in it. I mean, this is real dilemma. Now, Miller North, I point out here, and there's different cases with different judges and different facts could come to a different conclusion. And if they weren't an employee, and that's the case you brought us, the auto liability carrier has to address the damage, and there it goes against your auto liability coverage. So that pretty well brings this to where we wanted to go with this is passengers are a real problem here, and it exposes us to auto liability, but it also could expose the motor carrier to potentially no coverage at all, and they're going to be bare of any coverage. Am I reading this right, Bridgette?
You're exactly on point, and they may be facing a wrongful death case of $1 million without any coverage, and the concern is significant because you have to be aware of who's getting in your vehicle. I mean, in this case, it was April Miller, and in other cases, it may be a person that is interested in maybe operating for a company and gets in a vehicle, and there's that gray line of, well, they weren't really, were they an employee? They were just interested in maybe becoming a truck driver, or maybe they had their CDL, but they weren't an employee. They hadn't gone through all the qualification requirements and been drug tested and become an employee of this company. So you have to be really careful who you allow in your truck, because for these very reasons, you could be sitting in a situation where you're facing not only a wrongful death action or personal injury claims, but a declaratory action from your insurance company saying that they don't have any obligation to defend and indemnify you, the insured.
And this case, I remember being Miller and Northland. It's the first case I've been aware of, but there have been other cases that came to the same conclusion, has there not, Bridgette? That if you research this, and you track this far more than I do, but there's other cases in other jurisdictions that had come to the same conclusion. But there's also been some other cases that did not. So you're almost rolling the dice there, depending on the judge and the facts.
Right, exactly, and that's it. It's very case specific in terms of the arguments as to whether or not this individual meets the definition of an employee.
So this is what we had. In other words, be real careful. The best answer to this is don't allow it. But again, in the case that you had where your driver violated their rules, then we're stuck with this. And so, this goes back again to maybe event recorders and other things to police this kind of stuff. Any way to keep control of that is going to be important. But there is a positive part to keep good drivers there, to keep them with the company. And as we all know, driver shortage, and the driver has been there with the insured over a year, has fewer crashes than not. So what can we do to keep the good drivers there? This might be a benefit, but if it is, you want to be real careful with it. You also might want to get some ideas from the auto liability carriers on how they're going to treat a case like this. So we're out of time, Bridgette. So if anybody has any questions and answers, questions and seek answers, please type in the chat window, and we'll come back and address those, everybody, with an email later. And I hope you got something out of this time. Bridgette, you're wonderful. I really appreciate everything you and your firm and Jay does, what we help with annual conference and other things. And so if you want to say something in parting words, other than here's their address, and you're willing to talk to them and give them some kind of guidance if their motor carriers want to go down this path, but they need to do it carefully. So
yes, absolutely. And if anybody does have the answers, I'm all for answers, right?
Yeah.
Always a pleasure to help the members, and so here's my my phone number and my email address, so call anytime with any questions. I'm always happy to help.
Bridgette, thank you very much. We rely a lot on you to bring things forward that we need to think about. Here, we didn't come up with any answers. We came up with a problem and maybe some things they should do, but ended up with the conclusion that maybe there's not a real solid way to protect this stuff all the time. So this will be, thank you for making aware of the risk here. This is the truck stop here. Our next one will be December 14th at 2 p.m. and we'll let you know what we're going to discuss there. And with that, we're done. Thank you, Bridgette.
Thank you, Tommy.